Welcome back, ladies and gentlemen. We will get started with our second panel today, and I'll begin by introducing our panelists. Professor Darrell Miller is the Melvin G. Shim Distinguished Professor of Law at Duke University School of Law. Professor Miller writes and teaches in the area of civil rights, constitutional law, civil procedure, state and local government law, and legal history. Miller began his academic career at the University of Cincinnati College of Law. Prior to joining the academy, Professor Miller practiced complex and appellate litigation in Columbus, Ohio, after clerking for Judge R. Guy Cole, Jr. of the United States Court of Appeals for the Sixth Circuit. Andrew Willinger is the Executive Director of the Duke Center for Firearms Law and a lecturing fellow at Duke University School of Law. He writes and comments on Second Amendment decisions and issues related to firearms law, and is a frequent commentator in major media publications. Andrew graduated from Duke Law School in 2016 and was a staff editor for the Duke Law Journal. Professor Joseph Blocher is the Lantiel Smith Distinguished Professor of Law and Senior Associate Dean of Faculty and Research at Duke University School of Law. Professor Blocher's principal academic interests include federal and state constitutional law, the First and Second Amendments, legal history, and property. His current scholarship addresses issues of gun rights and regulation, free speech, the law of the territories, and the relationship between law and violence. He joined the Duke Law faculty in 2009 and received the law school's Distinguished Teaching Award in 2012. Professor Blocher received his BA magna cum laude and Phi Beta Kappa from Rice University and studied law and economic development as a Fulbright Scholar in Ghana and as a Gates Scholar at Cambridge University, where he received a Master's in Philosophy and Land Economy. He received his JD from Yale Law School. On Zoom, we have Professor Alexandra Filindra, who is an Associate Professor of Political Science and Psychology at the University of Illinois, Chicago. She specializes in American gun policies, immigration policy, race and ethnic politics, public opinion, and political psychology. Dr. Filindra received her PhD from Rutgers University and served as a postdoctoral researcher at Brown University's Taubman Center for Public Policy and American Institutions and the Center for the Study of Human Development. Her book, Race, Rights, and Rifles, will be published by the University of Chicago Press this year. Professor Reva Siegel is the Nicholas de Belleville-Katzenbach Professor of Law at Yale Law School. Her writings draw on legal history to explore questions of law and inequality, and to analyze how courts interact with representative government and popular movements when interpreting the Constitution. Professor Siegel is a member of the American Philosophical Society, a member of the American Academy of Arts and Sciences, and an honorary fellow of the American Society for Legal History. She serves on the Board of Advisors and the Board of Academic Advisors of the American Constitutional Society and on the General Council of the International Society of Public Law. Moderating this panel is Professor Jeffrey Pojanowski. Professor Pojanowski is Professor of Law at Notre Dame Law School. He joined the faculty and community of Notre Dame Law in 2010 and was promoted to full professor in 2015. He teaches and writes in the areas of administrative law, jurisprudence, legal interpretation, and torts. Professor Pojanowski earned his AB in public policy with highest honors from Princeton University and graduated magna cum laude from Harvard Law School in 2004. After law school, he served as a law clerk to then Judge John Roberts on the United States Court of Appeals for the District of Columbia Circuit, and then to Justice Anthony Kennedy of the Supreme Court of the United States. And with that, I'll turn it over to Professor Pojanowski.
All right, thank you everyone for being here today. I'm not going to say much in the way of introduction because you're not here to hear me. So I think, I guess, do we have a preference in order of papers to present? I see in the binder the Miller papers first, so let's let contingency take us there. So thank you very much.
Thank you very much. Thanks again to Notre Dame for this great opportunity to present this research, the excellent convening that we have today. I'm really excited to see these in print. So Bruin, as we've discussed, changed the dynamic for how Second Amendment cases are to be decided, to one focused on history and analogy. And if you're like me, you have a few empiricists on faculty. And I could see the despair in their face. You know, they thought that this was the future was sort of fact-free litigation, constitutional litigation over guns, that all the regressions and things that had been made about gun violence were all for naught, and that basically all these millions of dollars worth of studies were basically now just burned money. Alexandra, Noah, and I are far less certain that this despair is warranted, although we'll have to see what Rahimi gives us. We argue that the empirical data is still relevant, but that rather than themes of legitimate government interest and fit, the new Bruin test is one where the empirical data is made relevant by the scope of history and analogs. And we're going to discuss this new mode in light of traditional government regulatory purposes of preventing and reducing the terror of the people. So in terms of division of labor, I'm doing the law side because that's what I know how to do, and Alexandra is going to do the experimental because that's what she knows how to do the best, and I don't have any idea about how to run an experiment. So the context. In June of 2022, the court decided Bruin. Bruin was a case 15 years in the making, one that gun rights advocates had been waiting for. They put all their chips on that, and especially on this issue about methodology. How do we even figure out whether something violates the Second Amendment? How do we even figure out whether something's a Second Amendment test? The old test that was built up in the wake of District of Columbia versus Heller converged on an implementation strategy that had two components. One was a categorical test that was heavily inflected by history and the court's own pronouncements. Part two was a conventional means-in scrutiny that often involved intermediate scrutiny. But there was some grumbling in the lower courts, including, and most prominently, then Judge Brett Kavanaugh, now Justice, that thought all of this means-in scrutiny was just unguided balancing. Fast forward to Bruin, and that kind of balancing of the intermediate strict scrutiny type seems to have been jettisoned. We got a 6-3 majority decision written by Justice Thomas. No conventional tailoring is allowed. It's text and tradition all the way down in analyzing Second Amendment cases. So the new two-part framework says the following. We hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. At step two, to justify its regulation, the government may not simply posit that the regulation promotes an important interest. That was the old scrutiny analysis. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Now, the method of deciding whether something fits within this tradition is analogical reasoning. Now, how the majority describes this analogical reasoning and the inferences therefrom has been subject to some very pointed criticism, including Andy Koppelman at Northwestern, who just says that the inferences are totally fallacious. For example, some decisions in the lower courts have this kind of structure. There was little to no regulation of loaded firearms in modes of transportation in 1791. Therefore, it must have been that people thought that they had a right to carry firearms onto modes of transportation. Therefore, somebody might be able to carry a loaded firearm into the cabin of a jet airplane in 2023. That is the mode of reasoning that is occurring sometimes in the lower courts. Now, obviously, there's a whole lot of technological and social difference between the past and today. So how do we get to regulation on commercial jet airliners, which wasn't enacted, by the way, until 1961? This is where Justice Thomas says in Bruin, those kinds of issues implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. The regulatory challenges posed by firearms today are not always the same as that preoccupied the founders in 1791 or the Reconstruction generation in 1868. The more nuanced approach looks at the how and why of the regulations burdening the law-abiding citizens' right to armed self-defense. So, taking up this option, the more nuanced approach, there's a long history of controlling public weaponry to maintain the public peace and to prevent what was then described as the terror of the people. These can be variously grouped into three categories, although there's some historical leakage between them. One was prohibitions on what was known as a fray. A prohibition on a fray, which actually comes from the French word to frighten. This was a common law crime about two people engaged in a sudden fight, and according to 18th century writers, could occur when somebody was seen riding or going armed with dangerous and unusual weapons, even though there was no actual violence. And this leads to the second category, dangerous and unusual weapons. Another long-standing regulation was prohibiting people from carrying dangerous and unusual weapons, sometimes merged with crimes of going riding armed offensively. The fear generated by this type of conduct was the fear of not being armed as the other person is. And I think this is an unexplored and potentially very significant issue. When we think about this underappreciated aspect that Guha Krishnamurthy and Peter Saliv have written about in a piece called Small Arms Races. The fear of going unarmed when others are potentially armed creates a potentially suboptimal norm cascade, where everybody goes armed to a specific place, or people avoid that place because of arms. There's also a long-standing set of prohibitions on carrying guns into so-called sensitive places, such as fairs and markets, in the presence of the sovereign's ministers, and which the 19th century had extended into places of public amusement or education. Now, all of these historical regulations have as their prohibition, the why, the protection of public peace and the prevention of public fear. So while the whys about these kinds of regulations can be bridged across time, the capacity to generate fear is quite new. So let me just isolate a couple of technological facts pulling from what Professor Schauer had said before. So early firearms lost most of their kinetic energy around 50 yards. At 100 yards, at the very least, at 100 yards, a modern assault rifle can still penetrate steel. I think it's actually worthwhile to read a section here from my piece about the selling of the AR-15. So this was before a testimony about the AR-15. Quote, at combat ranges 0 to 500 yards, the AR-15 rifle will penetrate both helmet and liner, 15 to 14 1-inch pine boards, 10-gauge steel, or modern body armor. So if anything, I'm undercounting how much the technological capacity is different. And this technological capacity is happening at a time when we have an epidemic of gun violence in America, including mass shootings like the one that just occurred in a bowling alley in a restaurant last week in Lewiston, Maine. According to a report by what was then called the Kaiser Family Foundation, 84% of U.S. adults report taking at least one precaution to protect themselves and their families from the possibility of gun violence, including 35% who said that they've avoided large public gatherings, including music festivals or crowded bars and clubs. So we think that this idea of terror, this idea of the chilling effect on public life has some measurable consequences and can be measured empirically, and this is where my co-author comes in to talk about the survey experiment that she performed.
I'm here. Let me share the screen. I'm having some issues with, the screen sharing is disabled. Might somebody be able to allow me to share screen?
Go ahead and try it now.
All right, there we go. So As Professor Miller said, as part of this paper, we have incorporated an experiment or a set of experiments to estimate what we call the chilling effects of public carry. What do we mean by chilling effects? We define chilling effects in terms of unwillingness to visit public spaces, both social and political, because of the potential presence of firearms in such spaces. So a chilling effect is, in essence, the difference between people's behavior in the absence of firearms in a public space compared to the presence of firearms in the same space. So our purpose is to understand whether the potential presence of firearms could produce such chilling effects. We conducted a series of survey experiments that were embedded in a larger survey, a nationally representative survey of about 3,000 people conducted in March 2023 by the survey company YouGov. Respondents were essentially randomly assigned to either a control group or to a treatment group. And a control group basically did not mention firearms, whereas the treatment group included the wording, if guns are allowed in public spaces. We use an experimental procedure rather than just simply asking straight up questions in an observational fashion, because it allows us to establish the difference and talk about cause and effect relationships. By randomly assigning people to these conditions, we eliminate the possibility that some other factor, whether personality or a sociological factor, may be what influences behavior, because we are expecting that those factors are randomly assigned in the population as well. Essentially, a survey experiment is the same idea as that used in drug trials. So the first study asked in the control group, how likely would you be to recommend to a friend who has children to spend time with the children in a public park in your town? And the second half of the people received the same question, except the question also included if people are allowed to carry guns in public parks. The question response categories were the same in both cases. And what we see, the blue represents the proportion of the people in the control group who said somewhat, very likely or somewhat likely, and the red represents the same thing for the treatment group. So in the entire population, the first figure 1A, shows for the entire population the difference between the control and the treatment. And the overall chilling effect here, the drop between the control version, the treatment version, is about 27 percentage points. Figure 2 shows the differences broken up by gun-owning households. And we see that even among gun-owning households, there is a substantial drop. It's not, the chilling effect is not as large, but it is present. And we see that chilling effects persist for gender and across race groups. Both whites and non-whites exhibit large chilling effects. In the second experiment, we asked the same pretty much question about open-air markets, where we asked whether if you and your family, how safe would you and your family feel going shopping in an open-air market, such as a farmer's market. And the treatment version, again, talked about if guns are allowed. Here again, we see a similar chilling effect overall of 27 percentage points. And the chilling effect persists across demographic groups and even among people who have guns at home or from gun-owning households, we see a smaller chilling effect of about 14 points, but it is a significant chilling effect nonetheless, even among this group. The third question asked about a friend who's thinking of attending a political protest, and would you recommend to them, encourage them, or discourage them from attending? And again, the treatment, as previously, also mentions that guns could be allowed in public spaces. This is a harder question in a sense because the baseline is lower. As you can see, only 37% of people would encourage their friends to participate in a protest because people just don't necessarily like protests, they don't feel comfortable. So to capture chilling effects in this context is harder. And still we see a 13 percentage point drop between the control and the treatment. This persists among demographic groups. It's not significant when it comes to gun households, but it's still there directionally. This is an even higher difficulty question because we are asking whether you would encourage your friend to go to the protest carrying a sign. And a sign increases the risk because it makes the person more visible in the context of a tense situation like a protest. And even here, we see a chilling effect of 9 percentage points. Only 22% of the people in the treatment group said that they would encourage their friend to participate in such a protest with a sign. And we see these effects to persist across demographic groups and less so among those with a gun from gun-owning households. We also asked, how safe do you think it will be for you to vote in person in the next presidential election? And if people were allowed to carry firearms in election centers. I know most states now don't allow this, but we included this to check, to establish that there's still chilling effects. And in fact, the chilling effect is enormous. It's 36 percentage points between the control and the treatment groups. It is very large even for people from gun-owning households and for other demographic groups as well. And the final experiment asked, how safe would you feel to vote by dropping your ballot box in a ballot collection box if people who are armed are allowed to patrol around such collection boxes? This is inspired by what happened in Arizona a couple of years ago. And again, we see very, very large chilling effects, 28 percentage points overall. They persist across all groups, all categories. So using survey experiments here, we document that the potential presence of firearms in both social spaces like parks and political spaces like polling centers can produce substantial chilling effects. And when people are informed that guns may be allowed in these spaces, they're less likely to want to visit, recommend to others to visit, and to engage in activities related to these public spaces. The potential presence of firearms has implications for people's ability to exercise political rights as well. People are less likely to encourage others to participate in protest activity. They're even more reluctant to encourage people to visibly express their political views, which allows us to extrapolate that the average person would not feel safe in a protest when guns are allowed. The presence of firearms near or at polling stations can produce chilling effects, as people may not feel safe to go and cast ballots. And the same may be the case for ballot collection boxes. People may not feel safe to drop off their ballots at the ballot box. So we are documenting large effects, large chilling effects, both political and social, when it comes to the presence of firearms in public spaces. Thank you. And
Thank you very much for that paper. So the way we're going to structure this, we're going to have roughly 15 minutes per presentation. That'll leave us time for question and answer. We'll give the panelists an opportunity to ask each other questions first. I may slip one in, and then we'll go to the crowd. Andrew, would you like to go next?
Thank you so much, and I just want to echo the thanks that others have expressed to the Law Review. As someone who sort of wearing two hats with regard to the symposium, I've seen firsthand how much work went into this, so truly we appreciate it. I'm here to talk about my paper, which is titled Bruin's Enforcement Puzzle. And I think to start off and sort of set the stage, it makes sense to differentiate between two categories of potential historical analogs under the Bruin test. You might have laws that are historical gun laws that are facially discriminatory, right? That say certain categories of people, certain groups of people cannot possess, cannot purchase firearms. Unfortunately, there are a lot of these such laws from around the time of the founding, the colonial period. They bar African Americans, Native Americans, Catholics from having guns, purchasing guns. And there's been a lot of debate since Bruin about sort of what to do with these laws, right? Do you throw them out for purposes of the analogical inquiry? Do you abstract some higher level principle, some higher level regulatory principle that you might be able to apply to laws today? I'm not going to talk about that category of laws. What I'm looking at is a second category, which is facially neutral historical gun laws. There's no discrimination evident on the face of the law, nothing in the text of the law, where there is some suggestion, however, that the laws might have been enforced or applied in a discriminatory way, or where there's some suggestion of a hidden discriminatory taint. And enforcement is usually the sort of the main way that you might expect to prove that. If there's not legislative history, if there's not any kind of clear indication from the context in which the law was enacted. And I think this is ultimately a trickier and probably a more important question going forward under Bruin. There's not going to be a whole lot of debate about these facially discriminatory laws, right? It's not going to be worth doing the work of trying to see how they were enforced. We know how they were enforced. It says on the law that they were enforced against a certain group. But for facially neutral laws, the claim of latent discrimination or discriminatory application could in theory be raised as to any potential historical analog within the Bruin framework. And these suggestions are often raised as to public carry regulations, especially in the post-Civil War period, which are frequently invoked as possible analogs for things like sensitive places restrictions today. And as I said, this is going to often involve an inquiry into enforcement and arguments about how a specific historical gun law was enforced around the time right after it was enacted. And so that's the title, Bruin's Enforcement Puzzle. That's what enforcement refers to. I want to try to cover three major topics in my presentation today. So first I'm going to go through very briefly what Bruin says about the enforcement or application of historical gun laws. And second, I'll spend most of my time talking about the archival research project that forms the basis for this paper, which is that we picked one historical gun law from North Carolina, a concealed carry ban that was passed in 1879, and we actually looked at some of the underlying court records in one county as to how that law was applied. And third, if I have time, I'll try to identify a few takeaways from this project that I think could potentially guide the Second Amendment doctrine going forward. So first, what is this enforcement puzzle that Bruin creates, and what does Bruin say about enforcement evidence? So Bruin says in at least 2 places that evidence of possible discriminatory enforcement of a historical gun regulation may take that law outside of the bounds of the American historical tradition of gun regulation, right? So this might be one reason to discount the law for purposes of the analogical inquiry. And I have a few quotes from the Bruin decision that I'm going to put on the slides. But this is just, there's sort of an interesting exchange between the majority opinion and Justice Breyer's dissent, where Justice Breyer says, well, you know, why would we be discounting these laws? There hasn't really been much evidence that's been offered as to discriminatory enforcement. And the majority opinion, in a footnote, which you can see here, says the burden is with the government to establish the tradition of regulation, and that includes consistent, even enforcement, potentially, of the law, right? So this is, the burden is on the government in the first instance to show that a law was applied evenly and consistently. I mentioned that in 2 specific places, the majority opinion talks about enforcement of historical gun laws and potential discriminatory enforcement. So first, the majority references in a discussion of 19th century surety laws. The court says that there is evidence from a newspaper survey, actually by Professor Leiter, that there may have been pretextual enforcement of these laws against African Americans, and that is an additional reason to discount these laws within the analogical framework. And second, which is especially relevant to the project that we did in North Carolina, the majority says that Southern prohibitions on concealed carry of firearms were not always applied equally. So again, a suggestion about these laws being applied in a discriminatory manner at a historically important point in time. And here the court is citing, the citation that follows this is to legislative testimony, congressional testimony from the Reconstruction era. So the court isn't citing any primary source document showing how these laws were applied. It's citing testimony, you can see, from a police officer in Florida who says that there was discriminatory enforcement. So second part of this is that I'm going to describe the archival research project that forms the basis for the paper. And I'll spend most of my time here. Happy to answer more questions about this during the Q&A as well. So our goal was to take a deep dive into the historical enforcement of one specific gun law and try to determine how it was enforced, not by looking at secondary sources like newspapers or testimony from people who lived at the time, speculating about what the enforcement looked like, but actually going to the underlying court records. So the jurisdiction where these cases were brought, where people were prosecuted for violating a specific gun law, and trying to catalog those, and then cross-reference the names of the defendants with Ancestry.com and similar databases to determine race, and then see sort of how that looked, what kind of picture of enforcement that presents. We did this project over the course of an academic year. We had a team of research assistants who were excellent and looked at thousands of pages of old court minute books in the North Carolina State Archives in Raleigh. And the specific law that we chose for this project was an 1879 concealed carry ban. This was a statewide ban. It applied to pistols and other kinds of deadly weapons that are listed in the statute. The law made it a misdemeanor offense to carry a concealed weapon in violation of the law, and said that upon conviction, somebody could be either fined or imprisoned. So one threshold question that we had to tackle for this project was what county to choose, right? Where would we look? As I'll talk about, and as I think is probably evident already, this is a very difficult undertaking. And so it's not possible to do this at scale across the state. And one reason is that a lot of the records simply aren't preserved. So there were many counties where we were not confident that these records existed, that records of the specific jurisdiction where these cases would have been brought. So we ended up choosing New Hanover County, which you can see on the slide here is in the southeastern part of North Carolina. It's home to the town of Wilmington. And we chose New Hanover County for a variety of reasons. First, the records were available. It's a big one. Second, we had the good fortune of having some local librarians who were able to help us and kind of advise on where these records were actually located and what it would look like to go and review them. We also wanted a county that had some sort of geographic and demographic variety. So New Hanover County has Wilmington, which it actually is the largest city in the state for, I think, almost all of this time period. And also rural areas surrounding the city, so it has that kind of balance. And also, as I'll show on a slide a little bit later, it has a balance of a black and white population at this time. So the population is always between about 60 and 40, either 60 and 40% either way. So in terms of actually finding these records and looking at them, I have up on the slide here one of the pages of the minute books that our research assistants had to decipher. And you know, the threshold issue of figuring out where these cases were even brought was very difficult. We spoke to, as I said, local librarians, archivists, experts on the North Carolina state court system at this time. One emeritus professor at the University of North Carolina was very kind to respond to my inquiries and sent me, I think, a 1 or 2 sentence email saying it was notorious that the North Carolina court system, if it was a system at all, was a mess. So essentially, good luck. I think the issue that this surfaces is jurisdictional overlap, right? And the fact that there was not consistency in terms of where these cases were brought, what courts they would have been brought in. What we ended up reviewing, and what you can see on this slide, are pages from the county criminal court minutes from this time period. Those records are relatively well preserved. We had most of the years between 1879 when the law was passed until about 1908. But we know that there were also prosecutions under the concealed carry law in other places, in other courts. For example, a mayor's court that existed in Wilmington. We know those were brought because we have some newspaper accounts, but there's no way to figure out whether those accounts are comprehensive. I doubt they were. And the actual court records don't seem to have been preserved. So as I said, you know, this is one of the pages, and you can just see here the notation CCW. So that's what our research assistants were looking for. That's commonly how this was abbreviated. And these are 2 separate prosecutions for violating the concealed carry law. That's carrying concealed weapons. And the second part of this project, so after we did this, after we looked through the thousands of pages of minute books, was then to go and take the names and look in ancestry databases to try to figure out race. That was also tricky because some of these are common names. One of the defendants here is Frank James, for example. And so, as you can imagine, there may be many results in the county, even at in this 30-year range. And so we weren't able to include, obviously, if there was a white individual and a black individual with the same name. We didn't include those in our results. So I'm going to show a few graphs now with the results of our research. This is nowhere near as fancy as Darrell and Alexandra's presentation, but I should caveat that I'm not an empiricist, so always worried when I put numbers and graphs up. But this first one just provides some context for our results. So these are the demographics of the county during the relevant time period from 1880 to 1910. As you can see, the county starts out about 60%, a little over 60% black, a little under 40% white, and over the course of this time period, the white population increases, the black population correspondingly decreases. I neglected to mention earlier when I talked about why we chose New Hanover County that in 1898 there was a violent white supremacist insurrection and massacre that overthrew the elected integrated government of the city of Wilmington, replaced it with a democratic white supremacist regime. And so that, it's no coincidence that you see these population trends. The white population surpasses the black population around the time right after the massacre, and many black, many prominent black leaders of the city were actually banished afterwards. So this was not, again, this is not a coincidence. This is happening in large part due to that event. So here are our results of the archival survey. And as you can see here, so let me go back real quick. If you average the population numbers over the course of this 30-year period, you get about 55% black, 45% white. So that's kind of a rudimentary way of just saying, if you average the numbers, that's what you're getting across this 30-year time period. These are our results of the concealed carry prosecutions that we were able to code as being prosecutions under the concealed carry law, and we were able to determine the race of the defendant with a high degree of confidence. This is a set of 141 prosecutions, and as you can see, the percentages align very closely with the county demographics over this time period. So 53.9% of the prosecutions were of black defendants, and 46% were of white defendants. And this was true even when we looked at sort of pre and post 1898, which, as I mentioned, is the date of this insurrection that overthrows the integrated government of the city of Wilmington. Many African Americans are killed or driven out of the county at that time. So you can see that after 1898, the percentage of white defendants being prosecuted under this law actually increases. That's not necessarily surprising because the county is becoming more white at this time as well. But we didn't find a vastly different set of circumstances after the 1898 insurrection as before. And I should say it's very important to note that these findings do not necessarily mean that there was not discriminatory enforcement in the county at the time. We have to consider issues such as social practice. For example, it may be that African Americans were much less likely to carry weapons in public in the first place. So maybe this does represent some level of discriminatory enforcement. That's impossible to know without further examination, to the extent that's possible, of what the accepted practices were at the time, who was carrying weapons, how many people were carrying weapons, and so on. And it suggests, I think, that the historical social practice is key to any kind of enforcement inquiry along these lines. So finally, our data also suggested potential discriminatory sentencing. So in terms of the defendants who were actually convicted or pled guilty and were sentenced for violating the concealed carry law, we found pretty strong evidence that there was discrimination in the sentences that were handed down. There are a lot of variables that could go into that. I'm not making any any declarations about what that means, and it's also a very small sample size because we were only able to do this for a subset of the 141 prosecutions. But as one example, of the 25 defendants that we were able to determine received a sentence of incarceration, hard labor, or both, 21 of those were black. So that gives you an idea of what might be going on with the sentencing. And you can see here, so this on the slide here, this is an individual, Ed Smith, who was convicted of violating both the concealed carry law, and also convicted of assault with a deadly weapon. And for violating the concealed carry law, he is sentenced, very hard to read this handwriting, but he's sentenced to 6 months on the public roads of the county. So that would be a sentence of hard labor. And I think this suggests that further research into possible discriminatory sentencing is certainly warranted. So finally, what are the potential takeaways here for Second Amendment cases in terms of how this type of evidence should be weighed by courts, and how these type of arguments that maybe historical gun laws that are facially neutral were applied in a discriminatory manner, how should those factor in to Second Amendment cases? I think if discriminatory enforcement does matter, and Bruin seems to say that it does, we should really have an interest in getting the history of how these laws were enforced and applied right. And there are a lot of problems with relying on secondary sources here. I think the primary one is just the denominator problem. We don't know how comprehensive these accounts were. For example, if we're relying on a newspaper that published something akin to a crime blotter, we have no clue if that was published on a regular basis, if maybe it was published on especially slow news days, right? We don't know when these concealed carry cases would have been included, when they wouldn't have been included. It's very hard to make any determinations that that's a real record of how a law was enforced. I think the types of court records that we looked at are potentially a better source in terms of being the primary evidence we have of enforcement, but there are a lot of issues with doing this type of analysis. First, it's just very complex and time intensive. I think there were 80 to 90 counties in the state of North Carolina at this time, so that gives you a sense of, this is one county that we picked for a 30-year period. As I mentioned, there are problems about jurisdictional overlap, just not knowing where these cases were brought, knowing that they were brought in many different courts potentially, but not even knowing what the full set is. There's the additional step of performing the demographic matching, which can be especially tricky, and then of course the fact that records often were lost or destroyed, especially when you go back this far. So many of these records, even if you can nail down the correct court, the records simply don't exist. And then you need to consider social practice, right? Social practice provides context for these results. You can't just sort of find the data and interpret it in the abstract. You need that context. So really quickly to conclude, Bruin says that its Second Amendment test accords with how we protect other constitutional rights. And so in my paper, I look a little bit at how the court has evaluated similar types of arguments about the relevance of discriminatory enforcement historically in other areas of constitutional law. And I think that's potentially a good guide or a good sort of suggestion for the path forward here. And the answer, to sum up very shortly, is that the court usually sets a very high bar for proving or making out a claim that a law is suspect because it was enforced in a discriminatory way or because there is some kind of hidden discriminatory taint that's not evident on the face of the law. Many of you, I'm sure, are familiar with the equal protection context, Washington v. Davis, and cases like McCleskey, where the court is very suspect of any effort to show discrimination through disparate enforcement or application. In some other areas, the court recently has seemed a little bit more receptive to these arguments, but continues to set a very high bar and generally place the burden of showing past discrimination, to the extent it's relevant today, on the party alleging the discrimination. For example, a recent case, Ramos v. Louisiana, dealing with the state's non-unanimous jury requirement, the majority opinion seems to say that discriminatory taint is relevant because the law was adopted at an all-white convention, constitutional convention in 1898 with the avowed goal of white supremacy. So there's that's a pretty high bar. A lot of these post-Civil War gun regulations, we don't have that, right? In North Carolina, for example, there were a number of black representatives in the state legislature at the time the 1879 law was passed, and a majority of them supported the law. We don't have much legislative history beyond that, but we know that a majority of them voted in favor of it. So recognizing that, here's just a quote from another context, the voting rights context, where the Supreme Court says pretty clearly that whenever a challenger claims that there was discriminatory intent behind a facially neutral law, the burden of proof lies with the challenger, with the party making that suggestion. And so recognizing that there are potentially important differences between these other areas and the post-Bruin Second Amendment, I think first among them that in these other areas you're talking about the actual law that is being challenged in court and whether it has some kind of discriminatory taint behind it. In Bruin, you're talking about a historical analog that might be used within the framework to support the modern law. But recognizing those differences, I argue that it may make sense to adopt some of these rules and some of these burdens from other areas of constitutional law in the Second Amendment context to recognize the complexity of these historical enforcement questions.
Thank you, Andrew. And finishing up, we have Joseph and Reva.
Thank you all again for being here. Thanks to our moderator for directing traffic. Reva and I are going to be tag teaming this brief talk. Our focus is on two cases. One you've heard a lot about, that's Bruin. The other we haven't discussed yet, and that is Rahimi, which is a fascinating case that surfaces a lot of the issues we've been discussing. In our work and in our comments today, we are going to be working within the Bruin framework, which I emphasize it is not a framework that we would have chosen. We have serious reservations about its articulation and its application, but despite its many flaws, we will argue that Bruin does not compel the result that the Fifth Circuit reached in the Rahimi case. Since we haven't discussed Rahimi, let me just give a brief overview of what's going on there. So since 1994, people who are subject to certain qualifying domestic violence restraining orders can be prohibited from possessing firearms under 18 U.S.C. 922 G8, which you all know, of course.
Tattooed on my arm.
Yeah. For simplicity's sake, I'll call this the domestic violence prohibitor, but just note this is about restraining orders, not about people convicted of domestic violence crimes. That's a separate prohibition. And in United States versus Rahimi, the Fifth Circuit declared that this provision violates the Second Amendment. This coming Tuesday, just days from now, the Supreme Court will hear oral argument in Rahimi. We're lucky enough to have with us today Rahimi's lawyer in an earlier stage, now a professor, but fourth in line, I understand, maybe have the oral argument on Tuesday. And we think this case provides a really important occasion for the court to clarify the kinds of public safety laws that are permissible under Bruin. The question we ask ourselves is, will the Roberts Court read the Second Amendment to forbid government from enacting a weapons regulation targeting the now well-established link between guns and domestic violence? Today, nearly half of women murdered in the United States are killed by an abusive partner or ex-partner, and more than half of those homicides are committed with a firearm. Women are 5 times more likely to be murdered by an abusive partner when that abuser has access to a gun. So partly because of these stakes of domestic violence, Rahimi has drawn a lot of attention. I think it's also drawn a lot of attention, rightly, for the questions it raises about the historical analogical method that we've been discussing today. And of course, Rahimi is not alone. Lower courts have struck down an increasing number of gun laws since Bruin, many of them interpreting it along the lines of the Fifth Circuit's decision, striking down the domestic violence prohibitor. Reva and I have argued in more detail elsewhere, although happy to talk about it today or try to keep my comments brief here, that the domestic violence prohibitor is constitutional under Bruin's historical test. You'll get the opposite view from Professor Beck later. But here we want to focus on how the Fifth Circuit and other federal courts are manipulating levels of generality in applying that test so that it could be used to strike down just about any modern gun law. And that means that Rahimi provides the Supreme Court with a critical occasion to uphold the domestic violence prohibitor and to reject the asymmetric application of Bruin's analogical framework. And here we're drawing on not just Bruin, but Heller. Both District of Columbia versus Heller and Bruin specifically authorize modern forms of gun regulation. In Heller, if you look especially to Part 3 of Justice Scalia's majority opinion, you will find an affirmation of the common law tradition that has long given government power to pass laws protecting the public against weapons threats. You heard a little bit about this in Professor Miller's presentation. Bruin itself specifically, explicitly in fact, contemplates changes in forms of regulation over time. It directs judges to use history as a guide to determine the kinds of regulations that are, in the court's phrase, consistent with this nation's historical tradition of firearms regulation. What Bruin does not require is that gun laws of today repeat those of the past, like some kind of grotesque Groundhog Day. But, ironically enough, on Groundhog Day of this year, the Fifth Circuit struck down the domestic violence prohibitor in Rahimi. That law, as I mentioned, adopted in 1994 as society came to better recognize women as equal rights holders, and as a critical mass of women came to enter politics, They demanded that government address the role that guns play in intimate partner violence, in enabling an abusive partner or ex-partner to coerce, threaten, terrorize, or to inflict physical harm and death in events that sometimes explode beyond the original targets to include multiple victims and sometimes even mass shootings. To justify its invalidation of 922G8, the Fifth Circuit's decision in Rahimi employs a method that we have called in our other work selective and asymmetric updating. And the way it does that is by interpreting the Second Amendment to protect weapons that did not exist at the founding, while insisting that government can only regulate the use of such weapons if it can point to enacted laws that closely resemble those on the books today. So the Fifth Circuit, in other words, invokes Bruin's history and tradition method to perpetuate, under the cover of the Second Amendment, a tradition of gun violence between intimates that the nation enacted 922G8 to repudiate. And the question before the court now, I think, will be, is this tradition of weapons, threats, and violence a tradition that the court is now prepared to entrench and honor in the Second Amendment's name? And again, I just want to emphasize that the court's decisions in Heller and Bruin authorize change, consistent with historical tradition in regulation as well as in rights. There's a line in the oral argument in Heller, in fact, going back a bit, but Chief Justice Roberts noted, and here I'm quoting, "We are talking about lineal descendants of the arms, but presumably there are lineal descendants of the restrictions as well." That's what we're trying to zero in on. And here's where Bruin's doctrinal framework comes back in. Professor Miller mentioned this a little bit earlier. There's an important passage of Bruin where the court indicates that application of its historical analogical test depends on whether the modern law being challenged addresses a societal problem that the founders might have addressed in the same way but did not, or whether instead the problem the law addresses is novel, involving, and here quoting again language you heard from Professor Miller, unprecedented societal concerns or dramatic technological changes unforeseen by the framers. In that category, the court applies the more nuanced approach in which the burden on the government to show historical analogs is correspondingly lessened. We believe that under either of these paths, the government should prevail in Rahimi, but they also spotlight, I think, how Bruin's test can be manipulated. That is, judges can require that regulations closely resemble laws of the distant past, even as they define the scope of the right expansively to protect weapons whose lethality the framers could not have envisioned. So that leaves us with a big question, which I will ask and then throw it to Reva to answer, which is, under Bruin's test, what is the societal problem addressed by 922G8? I'll throw it to you, Reva.
Okay, everyone. I guess I'm tag teaming here. I want to at least get in a word of thanks to the organizers, and I'll go right ahead. So, by its terms, 922G8 specifically addresses possession of a firearm or ammunition by individuals subject to qualifying domestic violence restraining orders. And it does not address domestic violence in any other context. So characterized, 922G8 addresses a societal problem that the Constitution's ratifiers did not experience. Domestic violence by gun was not a significant societal problem when the Second Amendment was adopted. In the founding era, historians tell us, quote, family and household homicides, most of which were caused by abuse or simple assaults that got out of control, were committed almost exclusively with weapons that were close to hand, close quote, not loaded guns, but rather, quote, whips, sticks, hoes, shovels, axes, knives, feet, or fists, close quote. A drunken, angry, or homicidal abuser would have been far less likely to load and fire an unwieldy black powder musket. So it is therefore unsurprising that the founding era legislatures did not adopt laws specifically disarming to some domestic abusers. Their guns were not the problem. Simply put, one important reason the framers didn't regulate the use of guns in domestic violence was that guns did not play a significant role in violence between intimates until much later. Some advocates, scholars, and judges have framed the relevant societal problem more broadly as domestic violence, full stop, or even interpersonal violence. Rahimi's brief and others emphasize that Americans at the time of the founding did respond to such violence, but did not enact laws specifically permitting judicial orders disarming those who threaten domestic abuse. The common law instead provided a battered woman, her relatives, and her community various alternative forms of deterrence and protection: homicide law, divorce law, and as Laura Edwards has shown, peace warrants and sureties. There was, in other words, a historical tradition of responding to domestic violence, even if that tradition did not provide women equal protection of the laws. But in Rahimi, the Fifth Circuit points to these earlier forms of regulation as grounds for striking down 922G8 because none of the identified historical antecedents was sufficiently like 922G8 in barring gun possession. In so doing, the court engineers a mismatch by describing the problem and the solution at different levels of generality. If the societal problem is defined broadly, then the search for regulatory antecedents must be similarly capacious, including not only gun-specific responses, but other modes of constraining domestic violence. Rahimi's own reading of the historical record then identifies necessary analogs, including sureties. But the court then dismisses them on the grounds they don't similarly burden the right to bear arms. This is a distinction without a difference if firearms were not prominent instruments of domestic violence at that time. As we've shown, either of two societal problem frames supports the constitutionality of 9G8. If we characterize the societal problem at which 922G8 responds to as domestic violence by gun, the problem to which the prohibitor responds has not persisted since the founding. In a case of this kind, Brune calls for a, quote, more nuanced approach, close quote, to analogical reasoning. When gun regulation responds to, quote, unprecedented societal concerns or dramatic technological changes. Rahimi involves both forms of change Brune mentions. The nation employed different types of law to regulate domestic violence as it responded to technological change affecting instruments of domestic violence, so the instruments of DV change, and as it responded to an evolving understanding of women's roles. So that's the change narrative which the framework picks up. If in the alternative we start where Rahimi does and find that domestic violence is a persistent societal problem that the founding generation faced, we should define as historical analogs all legal responses to DV that the common law afforded to deter and remedy the problem. From this vantage point, we can see that Rahimi manipulates levels of generality to create a one-way ratchet for gun rights that's not mandated by Brune itself. The opinion shows how deciding cases on the basis of non-evident or obscure historical sources doesn't constrain judicial discretion, as many originalists claim, but instead can conceal expression of a judge's personal preferences. Judge Corey Wilson, author of the Rahimi opinion, made clear in an NRA questionnaire filed as part of a run for office in Mississippi that he opposes most gun regulation, including universal background checks. So here, this strand of our argument is intersecting with the paper that Professor Schauer and Spellman presented earlier. What the Supreme Court and Rahimi must rule out is this mix and match approach by which judges describe societal problems broadly so that they seem continuous with modern life, but then restrict the search for regulatory antecedents narrowly, recognizing antecedents only as those laws that closely resemble modern regulations. There's temporal mismatch on that framework. On this selective appeal to the past, the Second Amendment protects the right of a person subject to a domestic violence restraining order to his AR-15, while at the same time prohibiting government efforts to disarm that person unless the intervention resembles common law interventions at a time when domestic violence by gun was not a leading cause of women's death. To conclude up here, our caution that asymmetric updating and manipulation of levels of generality enables judges, let me start that over. Our caution that asymmetric updating and manipulation of levels of generality enables judges to enforce and mask their values in deciding Second Amendment cases has added force in challenges to the domestic violence prohibitor. If gun libertarians prevail in Rahimi, they'll perpetuate traditions of exclusion and inequality in new form. Rahimi, and especially its precursor, United States versus Paris-Gallon, exemplify what I've sometimes called preservation through transformation. Judges will invoke a new reason, feminist accounts of laws discriminatory under protection of women in intimate relations, as a reason to strike down a law protecting women from violence in intimate relations. Here we have the old dressed up as new. These decisions illustrate exactly why observers object that the court's turn to history and tradition provides cover for entrenching inequality. Reasoning from history, as Broom does not mean repeating it. Recognizing traditions that deserve perpetuation unavoidably demands normative judgment. Indeed, much of what judges, lawyers, and citizens do in arguing from history is to draw cautionary lessons. That is what the court itself does in Heller and in Brune, as it expands the right to keep and bear arms, in part as a response to historical disarmament of disfavored groups. But concern about perpetuating inequality must even-handedly apply to the regulation side of the inquiry as well, or else, once again, it will be the interpreter's own values, their interest in expanding gun rights, and not concerns about history, equality, or fidelity even to the court's cases that is driving the outcome. Thanks.
Thank you, everyone, for your papers and your presentations. We have about 10 minutes for question and answers. And so first, I want to give the panelists the first opportunity to ask each other any questions they have about their work, if there are any such questions in the offing. Yes.
So I'm going to direct my question to Andrew, because we've talked about this before, but one of the things that I can't get my head around is, like, what does it matter? The Second Amendment itself is born of deeply sectarian, bigoted motivations, right? The argument about the Glorious Revolution is it's to topple a monarch who, in part, is trying to give Catholics a break in a deeply Protestant society, right? And so, to essentially advance the civil rights of Catholics, he is opposed. The first thing that happens when the Protestant monarchs come in, besides passing the Declaration of Right, which is supposed to be what the Second Amendment is based on, and is also expressly sectarian, is pass an arm for disarming Catholics. So, I'm not quite sure exactly how you think about what about the bigoted nature of the right? How does that, to the extent that it's tainted, doesn't the taint also apply on the right as well as the regulation? And if that's the case, then it's just a wash. It just doesn't matter, or does it just matter on both sides?
Yeah, I think you're absolutely right. I think that the way I would think about it is, the paper at least works within the Bruin framework, right? So I haven't thought that much about sort of how the arguments about discrimination behind the Second Amendment right factor into this. My goal is really just to say, we're not going to do this type of enforcement analysis on a broad scale, but if we do it in certain places, what does that lead us to conclude about the rules that the court should use for implementing the post-Bruin Second Amendment? I think the bigger question about how you consider discrimination behind the right itself is kind of one for the court, if those arguments ever gain currency there. But this is the idea is to say within this framework, can the court or can lower courts take rules from other areas where we may or may not have similar concerns about the underlying right, and implement some kind of framework for considering enforcement of this.
Professor Filindra, yes.
I would also want to ask about the North Carolina paper, obviously not on the legal aspect of it, but more on the empirical aspect of it. This is fascinating to me, but one concern is that you don't have information on the denominator coming in terms of how frequent was gun carry among groups in this era, and I would venture to say, just by my understanding of history, that it would have been very, very disparate. And also, I think that for an African American person to end up in court, the chances that a lot more would have been handled if caught with guns outside of court by, the Ku Klux Klan and other similar organizations that were active in the area, especially in this period. I think that what comes into court is actually not representative really of what may be happening on the ground, especially in an area that became so fraught as Wilmington, because Wilmington has become the par excellence example of the one place in the US where there was an actual coup. So it's a very unique case in many ways. How are you handling all of these difficulties that have to do both with data and with the very, very unique context of Wilmington?
Yeah, thanks so much for that question. And I think you're right that the context of Wilmington, I think makes this project potentially much more interesting and also more difficult. I think it's certainly true, and I've done some, again, together with the team that we have done some newspaper research in terms of looking at newspaper reports leading up to the coup in 1898, and guns are a big concern. So I think you're absolutely right that there may have been extrajudicial, people who might have been trying to take, they were certainly scared that the black citizens were stockpiling firearms prior to the insurrection. That's one of the things that sort of precipitated it. So I think that's definitely a possibility. And you're right, there's a denominator problem here that probably extends beyond just the question of the forum, right? That said, I think the relevance of our findings, it's at maybe a higher level of abstraction, which is just that, we could have done this project and we could have found basically zero enforcement against the white population, right? And there are some places, at least some court opinions, that suggest that was happening in other places in the South. And so we honestly didn't know what we were going to find when we did this project, and that's not what we found, right? So I think you're right, and I think probably I can do more in the paper to sort of caveat all of that, but I think that's the relevance that I see in this project.
Because especially of the context, are there partisan dynamics? Because you have the integrationist biracial government and biracial sort of Republican part, and then you have the hardcore racist Democrats. Are the people is there any way to know if the whites who are being arrested on these charges are kind of fit a political mold? That's political justifications for the arrests.
Yeah, that's a really fascinating question. I off the top of my head, I think probably not, unless there's some kind of party identification that's required. I doubt it. But you're right. I mean, there's sort of my understanding is a group of moderate Democrats that combines with the Republicans to create this fusionist government, and then they're obviously the sort of white supremacist wing of the Democratic Party, and that could be part of what's going on here as well.
So I'm gonna exercise my moderating privilege and ask Professor Millers and Filindra a couple questions about their paper, which was really interesting. First is about the kind of level of the survey data, and I wonder if you're going to have geographical particularity, because I think of my in-laws from West Virginia, and their fear of knowing people are walking around with concealed carry would be very different than people in Chicago or somewhere else, right? And so would we have to be making the affray type inquiry more textured in terms of, to the extent of kind of fear, would our surveying have to be more particular, because we might get variation across geographical regions? And my second is kind of the scope of the doctrinal implication. Is it, if generalized fear of weaponry in the wild would justify regulation, would that be limited to kind of certain types of guns, or just the mere fact that people are armed? So would this have implications for just kind of handguns, or would it be for kind of unusual weapons, of which they often kind of talk about with respect to the phrase? So I'm wondering what's the doctrinal implications of kind of limits that would be allowed under this kind of analogizing from the affray action.
To answer the empirical question, a random assignment takes care of the geographic concern. This is a national survey, so you expect that people from southern states and northern states are equally distributed across both conditions. So that shouldn't be an issue. The fact also that we are seeing the chilling effects among gun-owning households suggests that we would expect to see them in places where there are a lot of gun owners because they exist among gun-owning households. And in other local data that I have that replicate these experiments in a southern context, in a more localized fashion, a place that has a lot of gun owners, we also find very strong chilling effects, also that extend to gun-owning households, people, and in very different places. There, in that study, we even asked whether different types of parks, like remote parks, that are for camping and there's nobody there, like bears are over there. And even in those locations, people tended not to want to have others who are armed. So I expect the chilling effects would be present in West Virginia and in other southern states as well.
Thank you.
So I'll talk really quickly. One is that on the implications is, I guess, a national survey it's really about what legislatures have the capacity to do within the framework of Bruin, not necessarily what they must do, right? Suppose if a state wants to say, as some states do, bring the guns to the courthouse, bring the guns to the, to the well of the assembly. Fine, they can do that, but this is about what is actually constitutional. The downstream effects is like the pushback. Like, is there a First Amendment issue that's now being surfaced by the licensing and the permission of this? As far as the law goes, obviously Bruin X's out a prohibition, a categorical prohibition of guns in public. That's what Bruin's holding is. But this does lend credence to, like, all right, if the point of what you're trying to do is regulate terror, what mitigates that, right? Obviously this helps with make sensitive places doctrine more rational. This would bolster things like training requirements. All right, it's one thing to have guns, but it's another thing to have guns which somebody knows, they're there and they're not just, untrained. So I think that's the doctrinal implications of this kind of research, with the exception of the macro issue, which is why we wrote the paper, which is we don't think that Bruin necessarily leads to the end of empirical data. It's just that the data has to be translated into a historical frame in a way that didn't exist prior.
Well, thank you so much. Real quick, because you stand between us and lunch.
Quick for Andrew.
No, we have time.
A quick one for Andrew. Just the problem you're addressing about enforcement, I think is maybe just as a suggestion for the framing of the paper, it's kind of a variant on the level of generality problem, which is why should the practices of interest be limited to enactments and exclude patterns of enforcement? And so a broadening question for the paper might be, it's not just discriminatory practices, it's just lack of enforcement, period. So you can think of things like destitute. There's a law that's been on the books for a long time, and it simply hasn't been enforced. Now, one kind of answer to that might be no stop, because enactments represent the sort of dispersed judgments of the representatives of ordinary people, while enforcements don't do that quite as well. Now, John Hart Ely and a number of other people are going to have criticisms of that view, but that's one kind of response. That's it.
Yeah, thank you so much for that. I appreciate it.
Thank you, everyone.